Chapter 6, Defenses to Liability Suits. The learning outcomes for Chapter 6. Define the 4 C's, relating them to workplace precautions that help to prevent medical malpractice lawsuits. Describe the various defenses to professional liability suits. Explain the purpose of quality improvement and risk management within a healthcare facility. And identify 5 different types of medical liability insurance. Here is a list of the key terms for Chapter 6. Preventing liability suits. Prevention is preferable to litigating a malpractice suit. So basically, it's easier if you can prevent a situation from going to a lawsuit or from going to court. So healthcare practitioners who use reasonable care in preventing professional liability claims are least likely to be faced with defending themselves against such claims. So basically, do your job, do it well, work on prevention, therefore you do not have to be part of a lawsuit. The 4 C's of medical malpractice prevention, those are located on page 139 of your textbook. So the first one is caring. As healthcare practitioners, it is important that you care about your patients and that you care about the oath you took as far as protecting them and doing your job. Communication, make sure you communicate with your coworkers, your superiors, subordinates, and also with your patients. Competence, make sure you fully understand your job as far as your clinical skills and your knowledge skills that you learned in your classes. And charting, it is very important that you document and chart everything that has to do with the patient. Why do patients sue? Patients sue because they haven't received a diagnosis, and that would usually be the type of diagnosis that could help them save their lives. A patient suffered an abnormal injury, probably from a surgery. Maybe a doctor did something incorrectly or dropped something on them or burned them while anesthetizing them. Failure to treat. Poor documentation of patient instructions and education. So make sure you document and chart everything. Errors in medication administration. You don't want to give a patient the wrong medication. They could be allergic. It could be life-threatening. Failure to follow safety procedures as far as keeping them safe. If they're a fall risk, make sure they have their band on and then make sure you check on them. Improperly obtaining / lack of informed consent. So you are not allowed to do something to a patient without them receiving informed consent. They have to basically okay whatever you are going to do to their body. And they also are allowed to refuse medication or services. Just put it in their chart that they refused the service and you did tell them the consequences of what could happen if they refused the medication or treatment. Communicating with patients. It is important to develop good listening skills. Make sure you call a patient back, hopefully the same day or maybe within the next day, and provide advice if that is your current position. Make sure patients fully understand their illnesses, that is thoroughly explained, and also the treatment options and the side effects of those things. Make sure informed consent forms are signed at all times. The patient has to sign off for anything that's going to happen to their body. And then avoid statements admitting fault. You could apologize for a patient experiencing something bad, but don't say, I'm sorry because I gave you the wrong medication or something like that. The company will separate itself from you and then fully blame you. So it's just not good to admit fault. You don't want somebody suing you or your family for everything when there might be insurance or policy through the hospital that might protect that. Communicating with patients, use tact, good judgment, and professionalism with patients. So you're not going to say things like, oh, we're going to cure you today, or oh, that's not going to kill you. So make sure you're completely professional. Don't use overly optimistic statements, making them believe something that's not really going to happen. Let patients know when the physician is going to be gone for a while. Some patients or some physicians take vacations. So especially if you have chronic patients, make sure they know ahead of time that their doctor will be out for a little bit, and make sure patients understand their fees, especially when it comes to dental. You might go in for a teeth cleaning, you might need a root canal, so it's just very important that a patient fully understands this before they commit to paying something that they cannot afford at the time. Documentation. Document everything. If it's not in the patient's record, then it didn't happen or it wasn't done. Types of defenses. There could be a denial of wrongdoing, and that would be saying that a situation didn't occur, or that maybe you weren't there when the situation occurred. You could say an affirmative defense, and that would be contributory negligence and comparative negligence. So contributory negligence is where the patient maybe contributed to them not recovering as quickly, or they contributed to their personal injury. And you're going to read a court case about that for this chapter and have a discussion on that. And then we have comparative negligence, where you might have two physicians involved in a situation, and maybe one was 70% at fault and one was 30% at fault. So the one that's 70% at fault would pay more in the lawsuit versus the one that was only 30% at fault. Assumption of risk. So when it comes to having surgery, there's an assumed risk that the patient might need a blood transfusion or bleed out, or something bad could happen. And then also when it comes to like taking pain meds, a patient will assume the risk that there could be some addiction involved, and just to keep that in mind through their course of treatment or therapy with the medication. And then for the emergency defense is when a true emergency exists. So maybe if you're doing the Heimlich on somebody and they were completely passed out, you're just doing it. So that would be an emergency, like you're trying to save their life. And then also using the appropriate standard of care provided. That could also be if there's like a dramatic accident and then you go to help a patient. So you're not going to charge them for those services. And they won't be able to sue you because you're trying to help them in case, even if something bad does happen, you were still doing the best for them and trying to save their life. These are technical defenses, release of the tortfeasor, res judicata, and statute of limitations. And the next couple slides will go over these. Release of tortfeasor. So it's a technical defense that prohibits a lawsuit against a person who caused an injury if he or she was expressly released from further liability in the settlement of a suit. So basically the victim cannot sue the physician unless the right to do so was reserved in the release. So an example of this could be when a patient goes in for surgery. So if something happens that's not within the doctor's control, then the patient can't sue them. A patient might have bleeding after surgery or hemorrhaging, and if there is no fault placed on the physician, then when they sign that informed consent, it tells them that there could be residual bleeding basically that happens after the surgery. So that's like a release of tortfeasor. Res judicata. The thing has been decided. So a claim can't be retried between the same parties if it has already been resolved. So if the court case is ended, you can't go back and then sue again for the same thing. Statute of limitations, so this varies from state to state, and it's usually about 2 years, but it could be 1 year, it could be 6 years. In the state of Kentucky, it's 1 year after you know something was wrong, and that's basically the amount of time you have to begin your lawsuit. Risk management. So this is important to minimize danger, hazard, and liability. So it may reduce the possibility of lawsuits. It'll help identify problem practices or behaviors, and it'll help problem solve to eliminate problems. Quality improvement / assurance. So programs uphold the quality of patient care and reduce liability risk. So basically treat the patients well, make sure they're taken care of, and that way there will be less risk of harm. Part of methods used to manage risk and includes following the federal, state, and local laws. Professional liability insurance. So this covers the cost of defending a medical malpractice lawsuit up to the policy limit. The cost of insurance is based on the physician's specialty and dollar amount of the policy, and is usually obtained to work in the hospital or with an HMO. Medical malpractice insurance types. So we have claims-made insurance, and this covers the insurer only for claims made, not for injury occurring while policy is in force. So basically this is going to cover anything for claims made while the policy is in force. So sort of like your car insurance. If you have your current policy and you have a car accident or something happen, then you're able to use your car insurance for that. So that would be the same thing as long as the policy is in force. Occurrence insurance covers the insurer for any claims made that occurred while policy is in force, regardless of when the claim is made. So it could be like an issue that happened before and it's just now coming up, like maybe it happened last year, but you're in a different policy. So it's going to work for those policies for when it was in force, for those claims for when the policy was in force, regardless of when the claim was made. So a claim could be made a year later. So during that time, you would go back and look at which policy was in force and use that. Tail coverage, basically if a person has used their claims-made insurance or occurrence insurance and they keep getting sued, so it doesn't come out of their household or their personal bank account, the person will buy tail coverage insurance, and that way it'll cover the rest of whatever they might owe. We have prior acts insurance coverage, so if something happened a while ago and then maybe the person is retired, so the prior acts insurance coverage would help if they get sued later, maybe something was discovered later on. So that would help with those situations. And we have self-insurance coverage, and that's like a trust fund that doctors can put money into in case they've exhausted all these other types of insurance. They still have the self-insurance coverage to help. Okay, so for week 4, I'm going to have you guys, I'm sorry, not week 4, for week 5. I'm going to have you guys turn in your healthcare paper with your paragraphs. I believe there's 13 paragraphs for that. And then also you're going to do a PowerPoint presentation on a disease or illness that I assigned to you. I'm going to post the list early in week 4, so that way, and then also on the homepage, so that way you guys can get started early on those if you want, but they're not due to the end of week 5.